Dear colleagues, dear members of the family, CEA family, I can say that. Thank you to have a will to listen to me again. I think that I am very often here, not only in Miskolc, but also in Miskolc for the third time, but also at all those conferences which are organized by the CEA and which are very difficult to extract all those contents of your activities. I'm very happy because of that, Professor Silogy. I think that you and your team and we as your wider team are doing really good, even great job. So if I am speaking about my topic after Petr, I am Petrov. So the topic will be a little bit different, will be constitutionally oriented, and it is related to some of my thoughts about what are necessary and what are unnecessary, or what are mandatory constitutional changes to the Constitution of Serbia, and what are those which are not mandatory on the European path, but I think that some of the constitutional provisions should be analyzed, maybe revised in this process, which are unfortunately not only in my point of view very slow and rather ambivalent, and of course in this especially sensitive moment it would be more ambivalent because not only of Serbia, but of course because of Serbia, but also because of the EU, because of some important risks or challenges which are facing the EU in this period and in the very close future. And considering my topic, I was dealing with some firstly ambivalences in the political position of Serbia from the beginning of the 21st century, and those ambivalences in the political position definitely caused some problems with, if I can say, with procedural democratic legitimacy of the Constitution of Serbia. As you can see, we see in 2007, after the adoption of the Serbian new constitution, which is rather strange way of in the procedure, because usually you should give the Venice Commission some time before adopting the constitution, and we did on opposite way. So the Venice Commission told that this procedure of adopting the constitution was motivated by important political consideration and reflected specific difficulties in the country. Nevertheless, it raises questions of the legitimacy of the text with respect to the general public. And when those legitimacy is quite disputable, then all the contents and constitutional provisions are also very if I cannot say disputable, but very subject to some kind of criticism in accordance with the true, not only declaratory European standards and values. And as you already know, because I was talking about it previously, Article 1 of the Constitution introduced rather vague formulation, European principles and values, and that is the part of the constitutional definition of Serbia. And there is no doubt that this formulation is flexible enough to include one day the principles and values of community law. So legally and substantially, Serbia is bound to respect European values and principles and make them integral part of its own constitutional identity. I was also talking about it in previous conferences. This does not mean that Serbian constitutional identity should be some kind of copy of the so-called European identity, because it is very difficult to say if there is something like this the European constitutional identity. I am pretty much sure that it is very wrong to say that there is a unique European constitutional identity. So definitely this is the identity which should comprise, or should in its origin takes the principles and values of national constitutional identity. So Article 1 of the Constitution of Serbia, by its flexibility in the part of that first article concerning European principles and values, is of value for the European path for the Serbia, even when it becomes, or when or if becomes, a member of the EU. And I was dealing on some topics what has been done so far. As you heard of me last time, the new constitution of Serbia in the part of judiciary was declared in 2022. It was confirmed on the obligatory on mandatory constitutional referendum, and I was analyzing that positive constitutional step towards European integration in the judicial reform in Serbia in light of the Venetian concept of the rule of law, the article which was published 2 years ago by Central European Journal of Comparative Law. And what must be done? So what are constitutional imperatives for Serbia, besides the formal one, which is related to the integration clause, because Serbian constitution, of course, does not have the integration clause. What is a very important topic, and what is considered by the Venice Commission and also by the European Commission, especially in its last report, is the reform of my institution or my function, the constitutional judiciary. I think that, in my opinion, this reform should be more wider than those which are evaluated by the Venice Commission, because in the opinion of the Venice Commission and also in the opinion of the European Commission, as you can see, it is related only to the qualified majority vote in the National Assembly for electing the judges of the Constitutional Court and to finding an adequate anti-deadlock mechanisms. But I think that it should be more wider than this, because, for example, we have, in my way, for a small country, a lot of constitutional judges. The number is 15, and some of you know that constitutional judge has to be the prominent lawyer. That is not only a pure legal standard, it is a very important condition for exercising independently, maximally independently the function of the constitutional judge. So I think that this number is too high. Also, I think that maybe we should analyze the opportunity for the judges to be re-elected. In my opinion, there should be only one mandate for the judge of the Constitutional Court, maybe even longer, but only one, because not to be motivated by any political goal or any other selfish interest to be again the judge. Actually, in this period of time in Serbia, to be a little bit more vivid, to give you the example from the current situation, we have, for example, the Constitutional Court, which lacks 4 judges, and that is the position which is not from yesterday. And we, in December this year, have almost the re-election of all judges. Probably some new judges will come, but there are some judges who probably wants to be here again, and it is very difficult to solve these problems, I think, in balance between those different interests. So I think that one mandate for the crown of the legal career of professor or lawyer anyway is definitely that. So re-election is not in my opinion, good solution. But in general, the constitutional justice is very important also in the European path and after that, because the Constitutional Court is one of the institutions which should be a real guarantor, a real watchdog of the real operation of the rule of law. And you probably heard that we have some risks about the operationalization of the rule of law in Serbia, and that unfortunately a lot of institutions are quite silent about it. Unfortunately, my institution too. I think that we should be more operative when we are talking about the current political problems which are in front of us. Sometimes it is not, you have to be enough courageous to say also to political opposition that they are not right. If we tell them 2 or 3 years after the situation that then that kind of decisions are almost without any use and without any sense. And what should be done in the Constitution of Serbia? I will just list some of the disputable provisions. For example, removing party imperative mandate. I will quote the Article 102, paragraph 2 of the Constitution reads, under the terms stipulated by the law, a deputy shall be free to irrevocably put his or her term of office at disposal to the political party upon which proposal he or she has been elected a deputy. You all know, even you who are not constitutional lawyers, but you pass the constitutional law exam, that this provision is quite disputable, that principle of the free representative mandate should be expressly declared, and that is the position of the Venice Commission and ODIHR, which reiterate the necessity to revoke the provision from the Constitution of Serbia to eliminate elements fundamentally at odds with the international standards of democratic elections. What should be done also? I think that we should think about relaxing our very complex procedure of changing, of amending the Constitution, especially in relation to implementation or to organization of the mandatory constitutional referendum, because a lot of constitutional questions which are named in Article 204, paragraph 7, a lot of constitutional questions should be dealt with in a mandatory constitutional, should be decided in a mandatory constitutional referendum, and that is not a good solution because that procedure is rather complex, and that it even make impossible some necessary changes to the constitution on the way to EU membership. So the drafter of the constitution should revise the procedure within the framework of the Assembly. I think that almost every part of the Constitution should be revised in the National Assembly with a 2/3 majority, except maybe some most important principles of the Constitution, which are all very well known to you, like the rule of law, the separation of powers or something, the system of government, which should be dealt only on mandatory constitutional referendum. Also, there are some other disputable provisions. I would point out only 2 of them at this presentation, and the first one is Article 16, international relations, and Article 194, hierarchy of domestic and international general legal acts, because we have some doubts about the hierarchy of our legal acts, especially those which are from the international origin, and that should be precisely defined before we enter the EU. Also, you probably heard of it. There is a potential problem about the presidentialization of our system of government, which is not only a constitutional problem, which is more political problem, but maybe we should think of especially revoking the Article 115, which allow incompatibility of positions, which allows constitutionally for the President of the Republic to be at the same time the President of the political party. Also, there are some other provisions which are disputable, but not necessarily amendable before we enter to the EU. And all stories about the constitution of Serbia and its European path always begin and end with the topic of Kosovo, because this is really for us, not only for us, the mission impossible. It is very difficult, and I don't think that it will be a solution which will suit the both sides, if I can say the sides, because it is from the point of view of the constitution of Serbia, not both sides, but one side, Serbia, and the Kosovo in Serbia. But unfortunately, the political process is in the kind of evolution, and we are necessarily talk about both sides or both parties. Kosovo and Serbia is very difficult to find some compromise between their very excessive demands. In my opinion, one scenario would be, but it is probably not realistic anymore, to constitutionally define Kosovo as an entity with practically all the elements of statehood without complete external appearance, international legal subjectivity, or at least not international legal subjectivity in its full capacity. But objectively, it is too late for that. Maybe it was a plan. It could have been the plan after the adoption of the constitution, but unfortunately, no government of Serbia from 2006 until today tried to even write a draft of constitutional law which defined substantial autonomy of Kosovo in some kind of constitutional framework for Serbia. And the second scenario is theoretically possible. I'm not sure which constitutional magician could be that person or that group of people or that organ who will try to constitutionalize all those Brussels Ohrid agreement in the constitution of Serbia, because it would certainly require thorough revision of the constitution, possibly the adoption of the new constitution, and there is uncertainty regarding the final result of such an action, because the question arises as to what would really be left for Serbia and what would be Kosovo for Serbia constitutionally in that kind of scenario. So there are a lot of topics, constitutionally relevant topics on the Serbian European path. Probably all of your state from which you come did not have some those kind of constitutional political challenges as Serbia has, but who knows, maybe, if I can say and conclude selfishly, maybe it is a kind of good thing for Serbia, because the EU is definitely, as my colleague Michal said, the EU is definitely the organization which future is probably safe, but the structure of it, the functioning of it, the look of it is very, very undefined in this moment. So maybe it will be the opportunity for Serbia to to get some kind of political decision to enter the EU without all those especially necessary or not anymore necessary constitutional amendments, especially related to those territorial problems and defining the final legal status of Kosovo. Thank you very much.